So now we're going to contract, the laws of contract. You well know that in term one, or I mean in semester one, you created a contract where you had to go through the aspect of creation of a contract. So after it is being created now, at this time we're going to see how does a contract end, or how is it, or how does it cease to operate. So you're going to realize that while you are classifying your contracts in semester one, you classified them into void and voidable. And you said that a void contract, this is one that is void ab initio, that is, it does not exist from the start, while voidable contracts, these are contracts that existed at the start, but due to certain factors, they are declared void. So we are going to see what makes a contract void, what makes it avoidable. So contracts will end in two ways. One, they will end in two ways. We are going to see vitiating factors, and then we are going to see termination itself and the remedies that may arise thereunder. So we are going to begin with the first vitiating factor. A vitiating factor, this is a factor that makes a contract either void or voidable, that is to cease to exist. There are around 4 or 5 vitiating factors that we have in law. So the first vitiating factor is mistake. The second one is misrepresentation. The third is undue influence. The fourth is duress, and the fifth is a misrepresentation. Around there are around 4 to 5 vitiating factors. Actual and illegality, there are 5. So we are going to see these vitiating factors that we have in law. So I'm going to begin with the mistake. When you realize mistake is where someone is mistaken, or like you are mistaken of something, either existence or something. Basically, you are operating on a mistake. You know a mistake. Something has occurred, or you do something but not knowing that either what you are doing is not right, or if it is right, maybe basically there is a mistake. So realize that mistakes are recognized in law. When you look at our section 2 will define what a mistake is of the Contracts Act. Then you will have to look at it generally in section 13 of the Contracts Act. But the result or the end result of a mistake under section 19 of, under section 17 of the Contracts Act, the mistake will make a contract null and void when you look at the provisions of section 17 of the Contracts Act. So with mistakes, we have to realize that they are classified, or they are types of mistakes. And majorly, there are 3 types of mistakes. So the first type of mistake is known as mutual mistake. A mutual mistake, this is where both parties are mistaken as to something that is pertinent in a contract. All of the parties don't know, or they are mistaken as to something in the contract. So that is mutual mistake. You are all mistaken of something. So majorly with mutual mistake, you'll have to read various cases, such as the case of Raffles versus Wichel House. The case of Raffles versus Wichel House will clearly explain, or will clearly show you what a mutual mistake is. But here, as you hear mutual, 2 of you are mistaken of something. Then the second type of mistake is what we call the common mistake. Now, what is common mistake? Common mistake, this time round, this is where we are going to break it into 2. There is what we call common mistake as to the existence of the subject matter of the contract. What is the subject matter of the contract? You realize that the subject matter of the contract is the reason as to why you people entered into a contract. So now, where there is a common mistake, there is a common mistake as to the existence of the subject matter, which we call the doctrine of res extincta. Now, what is this common mistake? This is where both parties, at the entering or at the start of entering the contract, they both thought that the subject matter of the contract, if it was a car that you were buying, The car is the subject matter. So you are both mistaken as to its existence, not knowing that by the time you concluded the contract, this car no longer existed. So that will become a common mistake as to the existence of the subject matter of the contract. Then the second type or categorization of common mistake is common mistake as to ownership, which we call as to ownership of the subject matter of the contract, which we can literally refer to as the doctrine of res sua. Actually, if you are to read common mistake in res extincta, you have to look at the case of Cotria versus Hasty. The case of Cotria versus Hasty clearly explains that aspect of res extincta. Then the second category of common mistake is common mistake as to regards or in regards to ownership of the subject matter, which you can also call the doctrine of res sua. Now this is where now these parties going to enter into a contract, not knowing that the buyer of the product is actually the owner of the product. It's like they are trying to sell you something which you don't know that that something belongs to you. So that one will become res sua. So that is common mistakes as to regards to identity, I mean to ownership of the subject matter. You buy something or you enter into a contract not knowing that something you are purchasing actually belongs to you. And you're going to see that that res sua principle was clearly explained in various provisions of the law. So basically, the third type of mistake other than common and mutual mistake, we have what we call the unilateral mistake. Now, what is the unilateral mistake? The unilateral mistake, this is now where one of the parties is under a mistake, but the other party is aware of the existence of this one's mistake. So unilateral mistake, this is where one of the parties to the contract is aware that the party is contracting with is operating under a mistake, but he keeps quiet while he's well aware of the mistake he or she is going through. So this person can challenge this contract because he will say that there was a unilateral mistake, and that was clearly explained in various cases. For example, the case of Lewis versus Avery. So the case of Lewis versus Avery will clearly explain the concept of unilateral mistake as alluded in the law of contract. That is unilateral, or that is mistake generally. Thank you.